A very important part of this clause kicks in, which is that it talks about the public domain. And unfortunately in New Zealand legislation and in this settlement agreement, there does not appear to be any definition of what public domain means. So I made an investigation into what the UK interpretation of it is, and essentially came up with an answer which was that it was a publicly accessible document or piece of information, and it was not subject to copyright. Now, at the point when we had submissions, Tauranga City Council offered no answer in terms of what the interpretation of public domain was, and Judge Ingalls mentioned several times that the understanding of that term public domain, along with the meaning of Clause 14, was of course critical to a lot of the matters before the court. Now, nowhere in this judgment has she clarified what public domain is, and so this fundamentally has a significant flaw associated with it. So the issue that then arises with this lack of definition of public domain is that if we're talking about other pieces of legislation, say to do with the criminal process, such as access to the court documents rules and the district court rules to do with access to court documents as well, which are there to put the documents in the public domain, then if they do that, then how on earth can there be a breach by me of this restriction by making use of a legitimate legislative instrument in order to put the document into the public domain? Now, this really comes down to fundamentally the integrity of other pieces of legislation and the way that the court will interpret that. And what we'll see later on is that the court's interpretation of this is that this restriction in the employment arena actually flows through to pretty much every other piece of legislation, including those in the criminal realm. So it's very interesting in terms of the precedent that this is setting, because essentially, without me having at any point revoked any rights under these other pieces of legislation, this clause here effectively is doing so. Clause 13 is the usual clause, which essentially is an attempt by organisations who are in strife to essentially up the ante in terms of the costs and grief they can cause the employee. So the employment legislation allows for certain fines which are generally in the $40,000 or less category, and essentially what this is an attempt, which is fairly typical, in order to allow the council, by way of other mechanisms, to actually collect more money than what would actually be the case in the employment legislation. So in terms of where we got to with the judgment of Judge Christina Ingalls, we have a number of things which needed to be addressed. First of all, what was public domain, because this was critical to the actual operation of Clause 14. That was never clarified. It was only myself who put forward a option there, which was that it was publicly accessible through some process and was free of copyright. That, to my way of thinking, makes the actual final decision fundamentally flawed, because it's based on a premise which we still don't actually understand. The second thing is the dissemination mechanism relevant if information is in the public domain? Because this once again comes back to what does the public domain mean. If somebody makes a request through Lagoima and the information is provided, the question that then arises here is, has Lagoima actually put the information into the public domain, or has the person who is requesting it? And I'll cover that one off a bit later. We also have a similar situation with the Protected Disclosure Act, where civil charges cannot be made because the Protected Disclosure Act explicitly rules against that. We also have the Local Government Act requirements in terms of the workplace, and nowhere that I can see in the judgment of 15th of April is any of that mentioned. Fundamentally, one has to ask whether or not the council, Tauranga City Council, has met its obligations there, and my view is that it most definitely has not. We also have a situation here where there's an overlap in the employment and criminal realms, and that situation has not been clarified, and essentially the judgment, in my view, takes the view that a employment confidentiality agreement, which is in the civil realm, can actually essentially flow into the criminal realm and impact a number of legislative acts there which would otherwise provide access to the information. The charges were withdrawn, not dismissed, so essentially there is still a cloud of suspicion hanging over me in my view, and so on the basis of that, while Judge Ingalls has claimed that because I never had to answer the charges in a court, I had to attend the court on 2 occasions, and that there was no need for me to actually have to vent my view on the criminal charges. So on that basis, the Criminal Disclosure Act is essentially redundant in terms of the information that was provided to me outside of the employment relationship, essentially cannot be disseminated, as is the case with the access to court documents as provided in district court rules and high court rules. In my view, abuse of the criminal justice system in an employment arena isn't dealt with in any way, which essentially comes back to the Local Government Act requirements in terms of the workplace. So quite a lot of sacrifice in terms of my view, the rights of an individual, and most of these areas here are acts which have essentially been brought into place in order to give every New Zealander a particular right, for example the Lagoima, and this right at no point in any of the settlement agreement have I actually revoked any of my rights under Criminal Disclosure Act, the district court rules, the Lagoima or anything, but essentially a employment confidentiality is concluded to supersede all of these areas, or there are various reasons why the information cannot be released in one form or another. Now, in my view, this is nothing more than stretching to the absolute maximum extent possible the life rope that has been handed to TCC. And what we'll see here is that effectively, as an example, Lagoima has essentially been crippled in terms of the operation for me, because while it's set up to provide accountability in terms of public spending and operation of local councils, what's in effect happened here is that the council wanted to really have the claim asserted that by making a request under Lagoima for something that was subject to the employment investigation, for example, that was actually a breach of the settlement agreement, whereas what the judge has actually said is that that isn't a breach, and that wasn't in fact pursued by the council at any length, but the release of the information from Lagoima is in fact a breach. Now, I'll cover Lagoima off in a little bit later on, but this is fundamentally crippling both the operation of the Protected Disclosure Act and the Lagoima in terms of how the intended operation of them is under the Act versus the actual operation for a staff member who has been employed by the organisation. The dilemma occurs when the council takes a matter to the Employment Relations Authority or the Employment Court, because like many other courts, the starting point there is that it is an open court. So what needs to happen is that the council needs some way in which they can still obtain non-publication orders while dealing with a matter before the courts. So the way that this actually pans out is that they, in this case, got in touch with Keith Hadley McGregor, who's an industrial psychologist, and essentially he then becomes an expert witness at the hearings in order to point out that staff at TCC who have been involved in all of this are highly stressed, and the stress has caused a generalized sense of fear, which then has essentially made them incapable of working and having long periods of sick leave. So we now have Keith Hadley McGregor before the employment court, he hasn't looked at any of the background as to why the Tauranga City Council staff find themselves in this situation, and has just gone in, once again, a bit like the Spark contractors, with as much as possible a blank slate, and reached various conclusions which aren't looking at the totality of the situation. And sure enough, the employment court then grants non-publication orders. The next thing that happens is that I happen to be in town, this is Tauranga CBD, Devonport Road, one day getting some outside chairs and a couple of other things, and lo and behold, who should I see on the street but one Grant Strang. So I sit down and wait for him to look up and take a photo with my phone as he was in a public place. This then leads to yet another sequence of actions. The sequence of actions is that the council then engages another barrister, Craig Stevens down in Wellington, and also engages Haikaka Investigations, as well as Keith Hadley McGregor, and essentially a three-pronged process occurs. What happens is that Keith Hadley McGregor, without actually ever speaking to me, decides that through his assessment of what staff have said, that I'm a dangerous person and that my firearms should be revoked. And he then, along with other documents from the council, then makes a submission to Wright-StClair at the Tauranga police station on Monmouth Street. Craig Stevens, the barrister in Wellington, is involved in all of this, and essentially we now have yet another case which then goes before the district court. Now the interesting thing here is that at the point in time when this all occurred and a whole lot of information was given to the police, there were of course non-publication orders in place by the court, and so what we enter into is the very murky realm of qualified privilege. And the council claims that they needed to do this in order to protect their staff, who were already highly stressed. And the employment court has to then make a judgment on this, and once again they determine that in fact what the council has done falls within the scope of qualified privilege, and the firearms revocation continues. So as part of the firearms revocation, if your firearms are revoked under the Act that applies the Arms Act, you can actually then appeal to the district court to have them returned, which I then subsequently did. So once again we have an interesting situation here where not only have we got an employment saga going, or has occurred, we have two criminal charges, but now we're actually in the district court with a firearms revocation whereby the actual basis of it centres around really the whole employment situation and investigation at Tauranga City Council. And this is going before yet another open court. So once again, this is causing a real spaghetti problem, and it's further complicated by the fact that Tauranga City Council themselves can't actually revoke the firearms that I have. They need to actually go through the New Zealand Police. So similar to the criminal investigation, essentially in this case the council is forced to actually hand the matter over to the police, and the police will actually be undertaking the prosecution. So we're going to have all this information re-enter into another court system, and the council is once again essentially divorced from having much control over what happens to that information. So as a result of that, we have a lengthy affidavit by Wright-StClair. I think it's something of the order of 130 pages submitted to the district court, and that then goes through the various throes there. The police prosecutor involved then requests that non-publication orders be requested from Judge Ingram at the Tauranga District Court, and Judge Ingram declines. We then go through the firearms originating application and the hearing associated with that, and like I'm told, every other firearms revocation that has become before the Tauranga District Court. This one is also declined. The next thing that happens is that the police once again request non-publication orders, which Judge Ingram declines. And so we now have a situation where we have another pile of matters to do with the employment investigation sitting in an open court which have no non-publication orders. Now, under the district court rules, anybody can request the court documents, and it's up to the judge to make a determination on that. The options available to the judge are to just decline the application, and I would normally expect in that circumstance there'd be a reason given, to approve it, or to actually require that the person requesting it file an originating application which gives both parties, in this case myself and the New Zealand Police, a chance to go before the court and actually say why the information should or should not be released. So that process is kicked off by somebody I know, and sure enough, even though there's no non-publication orders, the judge just flatly refuses access to any of the court documents. So a interesting situation, and there's no reason given for that, and so as a result of that I have escalated the matter to the Judicial Conduct Commissioner, and that's been sitting with them for months and months and months and still no answer, and I'm told that they will eventually get to it. Tied in with this firearms revocation, because staff are so stressed, Haikaku Investigations, which is a Waihi based company, gets involved, no doubt at another whole ratepayer cost, and essentially they go around and check on the security of the various staff members' houses. No doubt, I suspect, have done some work in some areas there, probably at ratepayer cost as well, and they also undertake some spying on my life by sitting outside the property that I was located at the time, essentially monitoring me. Various snooping into my activities which Haikaku Investigations undertake, presumably to try to find something on me which the council can actually use to put an end to this long-running legal battle. Nothing from what I can see ever arises, and I become aware of the fact that there is somebody sitting outside the property I was residing at quite frequently. When I then go outside and have a good look at them, they decide that the game is over and head off, and that is the end of what appears to be the spying by, I believe, one Greg Tinsley from Haikaku Investigations. Now, I've got some further documentation on all of this in the documents that are provided, which I won't go into, but we now have further work being done by the council in order to make sure that their staff are not suffering undue stress as a result of the actions which have got themselves into this situation in the first place, in my opinion. In December 2015, we then have Louise Miller departing from Tauranga City Council in order to go back to the UK, where she then works at the East Dorset and Cambridge Partnership, which is once again a joint venture between two councils over in the UK, from what I can see, essentially trying to put in place some level of shared services, a area which she's proven to be completely hopeless, in my view, at Tauranga City. I then have a look into the legislation in the UK, and there is a UK Public Interest Disclosure Act. So I then make a submission to the Chief Executive at the East Dorset Council, who also is involved in the partnership in terms of Louise Miller's involvement. And the upshot of this is that Louise Miller, within approximately, from what I can see, 2 to 2.5 months of that submission, is then back at Tauranga City Council. So she obviously seems to like travelling the maximum distance around the globe frequently, and the reason why she left, which was reported to staff at TCC, is that she had a sick relative back in the UK. So I guess that it is possible, although in my view fairly unlikely, that she also has a sick relative back here in New Zealand, but I leave you to conclude what you want from that. But the comment that I would make is that if Louise Miller was able to point out how this was all a big misunderstanding, I would have thought she was still employed over in the UK at the East Dorset and Cambridge Partnership. We also have another set of events occurring in parallel here, and these pertain to around about July 2016. Around this time we have a Audit New Zealand report which appears in Sun Live about the hopeless security in terms of the server room at TCC. We also have an issue where a contractor has apparently caused major problems with a cryptolocker virus at TCC in the months prior to this. And we then have a situation where, as I have been told, Grant Strang mysteriously does not appear at work for about a week. After that week is up, the staff are advised that Grant Strang will be departing for other work opportunities elsewhere, and he very promptly disappears. So in my view, there is only one conclusion that I would reach from this, is that what took me 3 days to figure out, and which I communicated with TCC management over the course of approximately 3 months, has taken the management 3 years to figure out, probably at enormous cost, and have eventually realised their mistake. The next phase in this whole saga is that obviously Tauranga City Council want to try to put an end to the ongoing litigation, and pretty much at this point there's really only one avenue left to them, which is essentially to get money off me. In other words, initiate bankruptcy proceedings. So there's other action which has occurred, which has gone through the Court of Appeal and then ultimately to the Supreme Court, which was ineffective in terms of changing anything. And so the council initiates bankruptcy proceedings at the Tauranga District Court, and this is taking an employment confidentiality matter and putting it before an open court. Now, in the process of the various submissions to the District Court, like they do in every other court, they request non-publication orders, and in this case Judge Bell at the Tauranga District Court has determined that the documents that Tauranga City Council have submitted are subject to non-publication orders, and that the documents that I submit are not. So they're still potentially subject to a decision if somebody was to request them, but there is no non-publication orders. So the bankruptcy part of this proceeds, and I pay the $3,900 approximately that the council is after, which was fees incurred in the Court of Appeal, I believe. And what then happens is that because the council is unable to get non-publication orders in the District Court, and because I've also lodged a complaint to the Psychologist Board about the behaviour of Keith Hadley McGregor, they then initiate another set of employment court proceedings. Now this employment court proceeding, this latest one, essentially is really doing three things. It's trying to basically claim that the documents submitted to the District Court breach confidentiality, and as a result of breaching confidentiality, they're essentially back in the employment court seeking further costs and other fees from me. The second thing is that by making a complaint to keep, the Psychologist Board, I also breached confidentiality, which once again falls into the situation similar to the breach that TCC caused when they provided information to the New Zealand Police to do with the firearms revocation. And then the third thing is that I provide information to two councillors, Larry Baldock and Greg Brownless, the Mayor, in terms of what has actually happened here. And the basis for that is that the only group of people who are legally able to discipline or determine the payments in terms of performance payments for the CEO and appoint and dismiss a CEO are the councillors. So I have provided them, these two particular councillors, or Mayor and a councillor, with all the information about what has actually happened. Now the councillors involved have no interest in getting involved in this, and I suspect that's on the basis of information provided to them by Kirsty Downey-Maguire and the legal team there. But anyway, that is also fed into the employment court again in terms of that being a breach of confidentiality. So what we now have is, instead of Christina Ingalls presiding on this particular case, we now have Judge for this latest employment court case, which Judge Corkle is presiding over. We then have essentially a very interesting scenario where essentially the qualified privilege which the council used with the New Zealand Police to do with firearms has been turned against them, and I'm essentially using it. So I am claiming that the information provided in terms of the complaint about Keith Hadley McGregor falls under qualified privilege. I'm also claiming that the information that is provided to the district court isn't subject to employment confidentiality because it is of relevance to the proceeding there, and in any event it is up to that court to make a judgment as to whether or not non-publication orders should exist, and the fact that they haven't given them, the council, the non-publication orders they wanted is really of no concern of this court. And then the last claim is that essentially the information provided to the councillor Larry Baldock and also to Greg Brownless essentially falls under qualified privilege as well, in the sense that the criteria that generally is required here is that it is a disclosure to a limited group of people, which it is. It is a disclosure to a group of people who are competent in addressing the issue or the matter that is being raised. The disclosure is needed in the interests of the public or other requirements which are at a high level in terms of the significance, and essentially the disclosure is such that it doesn't necessarily need to go any further afield unless that group of people choose to do so. So when we get into the employment court for this, and this is insignificant amounts of paperwork compared to the first employment court case, but this is the paperwork that Matthew Ward Johnson provides to the employment court, and this is in relation to qualified privilege. So the ratepayers paid for him to investigate 11 cases in which qualified privilege applies, and of course the whole purpose of that is to debate the use of my qualified privilege in my context. We then have another bundle of documents which are a further 16 cases which relate to other legal matters, in which once again it's trying to use this information to benefit the council in some way in regards to the 3 claims that they have. We then have other evidential documents, all of which the ratepayer probably isn't aware they've paid for, and then a document from me. So this goes before Judge Corkle, and I've included that judgment in the bundle of documents, and once again that's very interesting from my point of view. The judgment from Judge Corkle basically throws away the claim that the information provided for bankruptcy proceedings before the district court was subject to employment confidentiality, and reaches the same conclusion as what I basically was saying, which was that it was up to that court to decide what the situation was there. The second thing is that the complaint but Keith Hadley McGregor also falls under the category of qualified privilege, so no success there for the council in terms of getting anywhere. Then the third one, in relation to the information provided to the councillors, the judge finds me guilty in regards to that. Now that is for me very, very interesting, because the information has been provided to the only legal entity who can actually carry out any actions in terms of the behaviour of the CEO. So in Judge Corkle claiming that the information should not have been provided, we actually have the deliberate disablement of the only mechanism by which the CEO can be held to account for actions involving the workplace and the Local Government Act and its requirements therein. So from my point of view, just like the judgment from Judge Christina Ingalls, the outcome, which I think is a real stretch to give the council any sort of outcome, is essentially done at another price, and a price that the community and society in New Zealand pays as a whole. And the price is once again further information hiding about somebody who is paid a very high salary and which in my view is not doing their job. You might ask yourself, why have I made all this information available, which will of course come at great risk to myself? And the answer to that is that I'm actually not here to create a big hornet's nest, but I'm actually here to ask some high level questions about what is it that we're really wanting in terms of the society in New Zealand, and in particular the moving forward of local governments to address the increasing issues that exist in New Zealand society. So first off, I have an issue with the operation of the employment courts in relation to local councils. And the reason I have this issue is that unlike a private business, a local council operates as a monopoly. It isn't there for private benefit, in other words profits, it's actually there for public benefit. Its existence isn't subject to earning a particular income. Its existence is guaranteed through legislation. And the other part of this is that when you have a staff member who is subject to employment confidentiality, if you actually strip away all of their rights, whether it be through Lagoima, Protected Disclosure Act and other things, you've really got to ask yourself, why are you throwing away a source of information which might be the most reliable and the most beneficial in terms of actually advancing what this local council does for the community? Now, tied in with this is the fact that the general characterisation from my point of view of the Employment Court and the Employment Relations Authority in that respect as well, is that when there is actually a settlement agreement, they really want to know nothing about any of the sickness that's occurred during that settlement agreement. It's final and complete settlement. Now, the issue that arises for me here as well is that the Local Government Act makes certain requirements in terms of workplace, and the general view I would have is that its purpose is to actually elevate the workplace above that which would normally be found in a private enterprise. Now, in this particular situation, given the amount of money that a local council has, and in this particular case I believe TCC would have access to over $130 million worth of funds, and that is then coupled with things like Lagoima by default being disabled in terms of workplace management and what goes on in that scenario, we then have a situation where it effectively is backdoor stuff. And when it's backdoor stuff and that amount of money is involved and can be spent without much accountability, as in this particular case, we really have an issue with the actual real operation of the council and the operation of Lagoima in terms of providing accountability. We also have another issue here, which is that to all intents and purposes, as far as I'm concerned, the operation of the two separate realms of the courts, which is the criminal and the civil, have actually created an interaction here which I believe is entirely undesirable. To all intents and purposes, the civil realm in terms of employment confidentiality is overriding what has actually occurred in the criminal realm. But the criminal realm, in terms of what's actually happened there, is what is going to be generally the most significant out of the two. And essentially in this case it has disabled the ability of myself to actually tell the story of what has happened in the criminal side of things on the basis that employment confidentiality exists. I believe that's fundamentally wrong, and it's fundamentally sick, because it also goes against the requirements of the New Zealand Bill of Rights in terms of what is fundamentally the right for people who are charged with criminal charges to have transparency, and tied in with that is the fact that they do not have a cloud of suspicion hanging over their head. This is exactly what has happened in this situation, because of course when the criminal charges were initiated by TCC in conjunction with the police, Tauranga City Council advised the staff at TCC about the basics of what had happened, but it would be illogical to conclude that they wouldn't actually know who that related to, and in fact that is evidenced by the amount of communication I had when all of this came to a head. Now, the other part of this is that when local councils get into shared initiatives like BOPLAS and essentially provide a shared service solution in certain areas, one has to ask yourself, who really is entitled to know what is actually going on when something like an employment issue arises? And in my view, it's necessary for all of the councils that are involved in that shared initiative to be aware of what's gone on, in particular when there is an employee who has been operating in that space. And the reason for that is that if you don't do that, you create a cloud of uncertainty, and that cloud of uncertainty comes about from the other councils not knowing and them reaching what I can see logically as only one of two conclusions. The first conclusion is that somehow what has actually happened is tied in with myself being a bad person, and if I was a bad person and they have trusted me, then obviously their judgment was flawed, in which case if somebody else comes along and tries to operate in this space, they're going to be aware of the fact that they had flawed judgment in trusting me in the first place, in which case they're probably going to be very cautious about getting involved in any other services with other councils that involve trust. And shared services, as far as I'm concerned, at the very cornerstone of it is trust. The second conclusion that they reach is that there was nothing wrong with me and that I'm a perfectly sane and sensible person, in which case TCC has developed a sickness, and then the question that then arises is, do they really want to be involved in a council that operates at such a high level of sickness? And in either case, the outcome from my point of view is the same, which is that initiatives like this, which will benefit the whole community, I believe, will fall on their face, and they will fall on their face until such time as all the staff involved at the various councils and that have all changed out, and essentially you go back to a clean slate. But once again, that could take years, and when you then go back to the clean slate, you're probably starting pretty close from scratch again, because over that intervening period of time, as a result of the distrust, there's probably been a disestablishment of any shared services rather than any sort of advancement or keeping them in place. So from my point of view, the work in terms of advancing local councils comes to a standstill in terms of addressing the new and upcoming community needs, and this actually has an impact on all members of the community, as well as an impact from the point of view of the sheer amount of cost that is being poured into this, and the fact that it was all avoidable with what was probably a very simple conversation. And for that to be the case is, for me, incredibly disappointing, because I can see the futility in anyone getting involved in advancing local government. You might as well move into the private enterprise, because local government sucks, and the actual advancement that you might very well be doing, like as in this case, in my view, may very well be used against you in an employment sort of scenario, and essentially be a complete and utter waste of time. And a complete and utter waste of time from your own personal satisfaction, in the sense that if you're trying to advance yourself, both financially and in terms of career, well, this will be a significant setback, as has been the case for myself. So this finding of mine comes as we now enter into the 4th year after this whole debacle. Pretty much tens of thousands of pieces of paper have been moved around. Absolutely enormous amounts of time have been consumed by council staff and other contractors assisting TCC in various regards in relation to this. The whole outcome of it is just fundamentally stupidity and malice everywhere, and the community as a whole has no idea what really is going on in the corridors at Tauranga City Council. The other part of this, which has resulted in the release of this video, is that I'm aware from the way that the court system works in conjunction with the people who set the legislation, which is the politicians, that essentially there should be a feedback loop such that the politicians can actually see what is going on in the employment space or in the court space, and actually make necessary adjustments to the legislation. There are two entities at work here: the courts, which need to interpret the legislation, and of course that interpretation may differ from what the politicians intended, and then of course further changes occur to the legislation, ideally to actually clarify what was actually intended if the wrong thing occurs, the wrong decision is made by the courts. Now in this particular case here, as with a lot of employment court cases, if you actually have non-publication orders and this level of confidentiality, how on earth is it possible for any politician who even wanted to actually make positive changes for New Zealanders to actually understand what had actually occurred and make those changes, because everything is covered in secrecy? So from my point of view, the feedback loop is broken when confidentiality exists like this, and when we're dealing with a local council, it is of paramount importance that they do the utmost that they can to benefit the community. Furthermore, given that the latest employment court results have caused the disablement of councillors in terms of being able to assess the CEO's, Gary Poole's, performance, I have an issue with that as well, in the sense that if we actually have people who have been appointed to positions whereby they have certain legal obligations, as well as certain things that they're supposed to be doing in order to advance the community as a whole, why are we deliberately disabling them by providing them with a information void when in fact that information might be quite relevant to where they want their council to head? Now that information of course is also all subject to confidentiality, so once again the feedback loop is broken in terms of actually being able to assess what's happened here and see how it's actually disabled the very people who should, in my view, have